Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to tell you about main points that you need to know if you are in removal proceedings. You probably hear on the news that there are more and more removal cases, or deportation cases being opened every day. And it's very important that if you are appeared in those proceedings, you need to know what you're doing. Not only from the point as to what you want to get, but it's very important also to comply with the procedural rules, how you want to get it. Well, number one, if you are representing yourself or you would like to educate yourself about what needs to be done in immigration court and how it needs to be done, the first document that you would want to read would be Immigration Court Practice Manual, because this is the Bible for the immigration court judges and lawyers. In that document, you would learn about the deadlines, for example, when you need to submit the motions, how you need to submit them. They give you examples of how the documents need to look like for the immigration court, because maybe, let's say asylum case, maybe you previously submitted documents for asylum case with USCIS, but now when you're in immigration court, you have to resubmit the same documents that will look differently. At times, the different format has to be used for those documents. So it's very important to know how. Because if you don't comply with the rules of submission, your document, you might have the best case in the world, but if the judge rejects the submission, then it's like you didn't file anything, right? So, second point, change of venue. The case, the jurisdiction of the immigration court vests where the person resides. So when the person is detained, very often the jurisdiction of the immigration court will be where the detention is taking place, right? Where the detention is happening. But after the person is released and the person moves to a different state, let's say somebody was detained at the border and the first immigration appearance was in Texas, because that's where they were, but now they moved to New York, they have to move the case to New York. Otherwise, if you don't move the case to New York, you will be called to appear in court in Texas, and you will have to pay traveling fees and everything else, and it will be no excuse if you don't do the right paperwork for that you could not appear in Texas because it's too expensive, too far for you to travel, or you didn't know that the case is going to be there. That's not going to be an excuse, okay? So that's very important. The rules also, how different applications are being considered in court nowadays are changing due to Trump administration's changes. They changed a lot. For example, you need to plan ahead now very carefully what you're going to be asking for the court to do if you need more time for something, because recently the rules of delays or asking for adjournments or to continue the case, to postpone the case, that rule was changed. Now it's on you, the applicant, to show that you have a good cause for the delay. For example, you say, well, Judge, I will be able to get a green card through the marriage with my spouse, but my I-130 is still pending. In the past, it wasn't even an issue the court will give you more time for I-130 to be decided. But now it seems you will need to really put your case, the best case forward, to convince the judge to give you this time, because according to the latest decision and regulations, it seems like the court doesn't have to give you any time anymore if you don't ask for it in a proper manner with supporting documents. That's very, very important to know that. It's called asking for continuance because of the collateral application is pending. Very, very important. But there are other instances where you may want to delay your case. Let's say right now your child is 20, but in 6 months the child turns 21 and the child is a US citizen, and we're able to sponsor you, and you really need these 6 months. All right, so there are different ways why you would ask for the delay, and you need to know how to do it properly. So that's very important. And the last point I would like to make is that it sounds very complicated, but it's nevertheless is true. When you go to immigration court, you need to know the latest rulings by Attorney General and Board of Immigration Appeals on various issues that may be relevant to your case. Because if you do not know that, you may be missing a lot. For example, in this summer, there was a change in law coming from the U.S. Supreme Court, where the court stated that notices to appear that do not have certain date and time for the person to appear in court actually are not valid. And under the U.S. Supreme Court decision, immigration court would not have jurisdiction even to hear your case. This argument right now I know is being rejected by the Board of Immigration Appeals, but what happens nevertheless is that many old cases can be reopened. There is a timeline, a deadline to do that, because you need to act promptly. You need to hurry up after the case law was changed to file your motion to reopen, reconsider. But if you do not know that, you will be missing an opportunity to correct your immigration situation. So that's very, very important. You can read more about immigration court and various aspects of immigration law practice or different issues on our website www.shoutsova.com. Thank you.